Thank you, Mandy. I can say that it's also a great pleasure for me to chair this evening today with this quite incredible lineup of speakers. So the title of the evening is Cause Lawyering in Palestine, Israel, Limitations and Possibilities of Legal Struggles. I just want to say a few words at the beginning before we got into the actual discussion. So the relations between law and resistance seems to be a paradoxical one, since if we understand law in the tradition of critical legal studies as an instrument of production and sustainment of the ruling order, why so many groups and individuals are actually using the law to resist, to subvert, to struggle against this very order? But it's possible to argue that while law is a field of struggle that entails the appropriation of the terms and procedures of this order, and it seems that it just reinforces this very order, we can see from historical experience that negotiation of this logic is also possible. And we see that subordinate people are able to transform the law sometimes in radical ways. So using the law as a strategy of struggle, of resistance, is not unique to Palestine. Israel, of course, and it's prevalent in many struggles against oppression, and most relevant to our context also in other settler colonial settings, Australia and Canada and the United States, just to name a few. But obviously tonight we are going to focus on what's going on here in Palestine, Israel. So today, this discussion is going to flesh out some of the paradoxes and possibilities of what is called cause lawyering. So maybe just a sentence about what is cause lawyering, if you are unfamiliar with the term, is any activity that seeks to use law or law-related means of changing law regulation to achieve greater social justice, both for individuals and for groups. So as I said before, I'm very happy to have these four leading legal practitioners next to me that deals also with different aspects of the legal system, from representing individuals in either military courts or lower courts, through petitions to the Supreme Court, and also with the appeal to international law and advocacy work. So I will shortly present each one of our speakers, and we will start with the questions. So Bishara is the acting general director of Adala, the legal center for the Arab minority rights in Israel, and director of land and the planning unit in Adala. She has worked with Adala since 2001. Diana Buttu is a lawyer that served as the legal advisor to the Palestinian negotiating team and was part of the war litigating team before the International Court of Justice. She maintains a law practice in Palestine focusing on international human rights law. Charles Shamas is a senior partner with the Matin Group, a human rights-based partnership in Palestine. His human rights practice specializes in international humanitarian law, human rights enforcement, and state responsibility. And Leah Tsemel is a lawyer that since 1972 has been defending Palestinians and their individual and national rights before Israeli courts. She received several awards for her dedication for human rights in Palestine. So we will now move to the actual discussion. I will ask basically three questions, and I will give each of the speakers about 5 minutes to respond, and I really ask you to respect this 5 minutes, so we will actually have time for the audience to participate. So the order that we will follow will be Suhad, Diana, Leah, and then finally Charles for each of the questions. I really ask you to reflect on your particular line of work in each of the questions, so also the audience can benefit from your different experiences and practices. So what do you think can be achieved through legal battles? And I don't just mean legal battle as litigating in court, but in the wider sense of using the law as a strategy of struggle which possibilities the law entails, and or also if you can reflect on what you have achieved with your clients. So we will start with Suhad.
Hi, good evening all, and thank you, Liane, for the introduction and for the invitation. I have 5 minutes for the first question, right? Not for Okay. Liane started with the relationship or the paradox in the relationship between law and resistance. And yeah, okay. I tend to, so remind me. And I want to start from the other side of it, the relationship between law and colonialism. And the paradox from us as lawyers, as resistant agents from dealing with the colonizers' law, and the difficulties we face there, and what this engagement entails in terms of the prices that we might pay if we take a law as a strategy rather than as a tool, and a restricted tool with a lot of limitations. And I will rather speak about examples from our experience with the Israeli judicial system, mainly the Supreme Court, which basically embodies the Israeli constitutional system and implements it through its court rulings. I will try to be short. There are a lot of examples, but basically, after 48 nationalizing the conflict, Israel vis-à-vis the Palestinian citizens, Israel vis-à-vis the Palestinian refugees through applying the Israeli law over all of the refugees' properties, and thus we as citizens decided to practice the Israeli law, knowing that it's a law that was drafted in a way to identify Israel as a Jewish state in ideology and in practice. I want to touch upon issues related to land planning, which is one of the core issues between the Palestinians, generally speaking, and the Israeli system, whether occupation, 48 refugees, and so on. So the first reaction was to engage within the Israeli law and the Israeli legal system without really much thinking. And we wanted to practice our citizenship. And if I want to start from the end, this practice failed. Because time after time, decision after decision, the Israeli legal system has emphasized that we are citizens, we have the right to approach the court, to approach the judicial justice system, but once we are in there, they perceive us as Palestinians, not as citizens, and our citizenship becomes a tool of subjugation. And I will bring a few examples related to a few topics that go back not only to the Nakba, but also to current policies. One is the Iqrit case. It's a very famous case. Iqrit is a destroyed village. Through the Nakba, the villagers became IDPs, internally displaced. In '53, they got a court ruling that enables them theoretically to go back to their property. Many years after, the State of Israel refused to implement the court decision. They went back to the court. In 2003, the court said, you cannot go back. And it's okay for the government not to implement the court's decisions from like 50 years ago, because you are Palestinians, because they are Jewish citizens living there. But because of the implications of your return back to the village, because of your national identity as Palestinians, we will not allow this. The second was the Lajoun, another destroyed village, which the court explicitly said that lands that were confiscated in the destroyed villages in early 50s.
Keep going.
We perceive these confiscations through the political atmosphere that period, and we refuse to implement any constitutional developments that happened through the Israeli legal system in the 90s, and interpreting our arbitrary confiscations through that period, meaning suspending constitutional rights of citizens. In Hiran, which is a more recent case, the court basically said that the government, the state of Israel, has absolute authority with a logic of no reasoning to displace Bedouin community to inhabit Jewish citizens on the ruins of their village. Again, suspending their constitutional right for the sake of the Jewish Zionist project of Jewizing. The Naqab Admissions Committee is another, excuse me, I can't get into detail because of time. Again, a law that basically manages the segregation system between Arab and Jewish residential areas in Israel. The Supreme Court said it's not right, but and if you read in between the lines, basically the court said, and it's a system that's been functioning for decades in Israel, it's okay to classify citizens on the basis of social suitability, cultural suitability, and so on, and so on. So the basic Zionist ideology becomes an integral part of the Israeli legal and constitutional system, and unfortunately it becomes the legal reality faced by the Palestinian citizens of Israel, and you can see the same, of course, in the West Bank, or 67 occupied territories. And this is a system that we need to deal with. And this is a system that reflects back on how we strategize legally and how we strategize politically, basically thinking about the implications, not only for the short run, but also for the long run, vis-a-vis not only Palestinian citizens and the Israeli system, but the Palestinian who are living in 48, related to the 67 occupied territories, related to the Palestinian refugees.
Thank you.
Thank you.
Thank you.
Diana.
Should I use this?
You can use that.
I can use this one?
Yeah.
Is that better? Hello? Yes. Okay. Thank you all for coming, and I want to thank you, Mandy, for inviting me, and Ilian as well. I'm delighted to be on such an esteemed panel with so many warm and friendly faces here, so thank you very much for coming. In relation to the first question of what can be achieved through legal battles, the answer is a lot and nothing at the same time. And the reason I say a lot and nothing at the same time is that I think in this particular context, in the context of Palestine, we have to distinguish between the various types of cases, and I'm sure Leah and Suhad will do a much better job at elucidating this than I will. But in some cases, one of the strategies and one of the reasons for going and pursuing legal battles is in order to, quote unquote, buy time. And you hear this among a lot of various NGOs who say that they know that the legal system is failing. It's a legal system that is not a system that is pure, in which you go in and if you just argue the right arguments, if you make the right assertions, then somehow the wisdom of the above is going to come down and shed some light, and everything's going to be undone. This is a system that is deliberately designed, as Suhad said, to work against you. It's a system in which, although you are going into the system perceived as a citizen, once you're before the system, you are actually treated as a Palestinian. And so, given that that is the reality, for many of the people who work in this field, a lot of the strategy is simply buy time, with the idea being that we know that the system is always going to fail, but maybe the international community will one day kick into action and one day be able to take some action. So that's on the will do nothing side. But on the sometimes can be effective side is that law is unfortunately, I hate to say this, it's actually a tool of the very powerful, and it's a language that many people understand. And when you advocate using legal terminology, for some reason, people seem to have a little bit of respect for that, although, you know, you might end up figuring out I'm one of these lawyers who doesn't really like the law, that this actually carries a great deal of weight. So when you are advocating and pushing for things outside of the context of a colonial legal system, sometimes these types of arguments carry some weight. For example, when going to the International Court of Justice back in the year 2004, I can't believe it's been that long, 2003, 2004, the idea that we were going to be going and working on a case that entailed the legality, or in fact the illegality of Israel's wall, was seen as something that was very positive outside the context of this place and outside of the corners of this court. And you can see the difference in approach in the way that the International Court of Justice addressed Israel's illegal wall versus the way that an Israeli court addresses this illegal wall, one being that it focuses on the context of colonialism, Israel, and the other being that it steps outside the context of colonialism and actually measures things against a legal system. Now, that's also not to say that international law is pure or clean, or that many victories can be achieved by it, because international law is just like any other law. Just in the same way that we end up seeing in countries like Canada, like the United States, like Great Britain and Australia elsewhere, that what are considered to be white-collar crimes, even though they affect more people, people get lesser prison terms than people who are not involved in white-collar crimes, things that are considered personal crimes where they get much higher sentences. So too, international law is problematic in that it is a reflection of power, and it is a reflection of the international legal system as it currently stands. The problem with the international legal system as it currently stands is that we've got Israel, who's been a very powerful country, who has for 50 years and approaching more than 50 years, been trying to change the system of international law. And so while we have this fantastic ruling from the International Court of Justice, one of the biggest deficiencies that we've seen with this court ruling is that, again, we're now relying on the international legal system to enforce this very advisory opinion. So just in the same way that for certain types of cases, I'll be done in a second. For certain types of cases, we need to buy time in order for the international legal system, or the international system, to kick in and work. So too, when it comes to going to the international system, namely the International Court of Justice or otherwise, we also are dependent upon the international community to quote unquote kick in before something gets done. So it's both a plus and a minus. There can be some achievements, there can be some gains, but a lot of it is not self-executing. Thank you. The benefit of speaking quickly.
All right, thank you. Thank you. Well, it's almost 50 years of occupation, and it's time to ask these questions exactly. And I think that after 50 years, what we can present now, we means those lawyers who are working in all these different fields, whether it's in the daily fight in the military courts, whether in the daily fights in the civil courts here in Israel, or in the Supreme Court of Justice. What have we achieved? Have we achieved anything? Could we achieve? And perhaps what damage have we caused? So, yes, as it was said before, we are facing a system that globally is talking about making Israel a Jewish state, as it's declared both in the non-constitution, the Declaration of the Independence of Israel, and in the daily practice. And we are, by these, I would say, big laws, we are dictated. First of all, after the 48 war, there were the absentees property. And later on, after 67, it did not change at all. We still suffer the same consequences here in the occupied territories, even in those that were annexed to Israel, like Jerusalem. And then we have the law of return, and at the same time, the family reunification, different laws that enable the Palestinians from the occupied territories, from the occupied Jerusalem, to have normal life. It's all created by different laws that are altogether making it one continuous occupation. And of course, I started as a very young lawyer with a lot of enthusiasm. And very quickly I realized that we cannot, as lawyers, we cannot really make a difference. We cannot really change the reality. What we can do is we can serve political forces who are against the occupation. We can serve the resistance against the occupation. We cannot replace it. And this is, I'm afraid, a very common mistake that is done again and again by over-legalizing the different struggles that are here against the occupation. No, we cannot replace the fighters. Just as well, the different associations cannot replace political parties. There is all the priority to the resistance, to the parties, to the political leaders who lead this camp. And lawyers can be near, they can be behind, they can help. Never did, I think so, never did a legal struggle replace the real struggle that should be. I'm afraid that looking backwards, in many, many cases, it even shut down many struggles. It was so more comfortable to go, let's go to the Supreme Court, we'll get a headline in the newspaper, and that was the end of it. We'll try to fight it legally, but not really by organizing the people to go against it. And the consequences are very sad, usually. There have been some successes, I don't say that they're not, but just as was said before, to put some obstacles before this running machine, this running train of occupation, to make something slower, to take it off the main line, but not really to make a big difference. Because we can see it now clearly, that the occupation and the settlements are systematic. They continue systematically, and although we win here or there, they change the reality in this country. I wanted to give an example of success just to keep us a little optimistic. For instance, one of those legal struggles, for instance, deportations. They started with deportation of individuals who were considered leaders, and then of groups of people who appeared as some leading figures of the Palestinian people, some people who can promise something, so we try to fight it. And then we reached the peak, was the deportation of 400 Islamic activists to South Lebanon, that we were so successful, not because of the legal struggle. We could be successful because we stopped them on the border with Lebanon. We could exactly win this 2 days in order to raise public opinion in the Arab world, to stop them from being dispersed all over Lebanon and all over the Arab world, as happened before in former deportations, and to put them together in the camp so they were kept there and could then come back, and made a big difference. So, but, sorry, I'm finishing. Near each and every success, there is a longer failure. We stopped the deportations meanwhile. We did not stop, though, what is I would say, came instead of the deportations. This is the targeted killings. So we succeeded here, and there is a new danger coming, and we'll talk perhaps later on about massive deportations.
Thank you. Much better. Thank you. This about
Thank you all for Mandy and Leanne for having me. I'm kind of a newcomer to this kind of discussion. I'm not a lawyer. I love law. And the way my work uses law is a bit, it takes a couple of steps back from the battles that have been described here, which tend to be focused on seeking Israeli judicial remedies. I try to operationalize, and our work tries to operationalize the customary duty of non-recognition in international law. So what we look at is how the dealings between states, third parties, including corporations, and Israeli actors who apply Israeli law. For us, the Israeli legal framework has been constructed in a manner that does not correspond to very basic rules of public international law as they are understood, applied, and internalized by third states, other states, including the United States, including the European Union. Now, we see the beginning of a remedy to this problem, namely the mandating of under the Israeli legal framework, the mandating of wrongful practice that is fundamentally oppressive to Palestinians and fundamentally internationally unlawful. So the starting point is the difference between Israel's legal framework and the law that others apply, and between Israel's interpretation of public international law and its obligations under it, and others' interpretations of their obligations and Israel's obligations under public international law. It's the differences that start a very important process that triggers the discovery by third parties that they cannot, to maintain the integrity of their own internal legal order, to respect their own positions and commitments in conformity with international law, they cannot give legal effect to the Israeli practice that is lawful under Israeli law, but internationally unlawful, and unlawful to recognize and give effect to under third-party law. So we deal with the function of international law, which is basically to repair, to correct the differences, the non-compliance, the systematic institutional deviance of a state actor. International law is the starting point of the remedy. But then people ask, well, what good does it do, international law? Okay, states take positions, they condemn a lot of Israeli practices in the occupied territories, and many of them actually quietly, more quietly, condemn a lot of Israel's internal practices. The problem is, the application of international law seems to stop with those declarative positions. You may get UN resolutions, you won't get a binding Security Council resolution very easily that would justify, let's say, coercive enforcement measures. So it seems that there's a standoff, that international law doesn't really do anything. But that's not really been the case. What we try to look at is the fact that the state of Israel and Israeli companies, Israeli natural persons, Israeli citizens, engage in many kinds of dealings with third parties, which requires the third party to accept and recognize as lawful the Israeli practices that they engage in. Okay. The work that we've done only goes to the third party and says, as you would go to a judge in the court, can the normative principles, the rigidities you have, can you allow yourself to permit these dealings to take place with the Israeli side on the basis of the practice, on the basis of the law that Israel applies internally? Now, the answers have begun to come. The European Union found that there were three issues. It had to implement its own legislation fully and effectively, and couldn't if it allowed certain dealings to take place on the basis of the Israeli practice that is conducted on the Israeli side. Secondly, the need for consistency. If existing EU legislation was not being violated, but was permitting the EU to give legal effect and recognize as lawful certain Israeli practice that violates rules of international law that the EU applies internally, then the law had to be amended. And they've had to amend a lot of their legislation when they discovered this. The fact is that the third party enforces by conditioning the conformity and compliance of the Israeli practice of those Israelis who want to deal with it, with the internal rules derived from public international law that they apply within their own legal framework. Conditioning of dealings is this basic social mechanism of regulation. It's the way norms get applied and enforced casually between people, between states, between corporations and states, between people and states, between people and corporations. So that's the beginning of my answer. Please stop.
Thank you. I would like to ask you all to continue basically on the reflection that we just started, and perhaps think about the other side. If we thought about possibilities of achievement, let's try to think also about limitations and obstacles, apart from the very institution of the law itself and the very system that it represents. So what are the greatest limitations or obstacles that you came across, and what are the ways that you found to avoid or minimize these limitations?
I want also through my answer to reflect on some of the issues that were raised by my colleagues. When a law becomes war by other means, pragmatism becomes very problematic. And the Palestinian case is certainly one good example of such bad pragmatism in many cases. I cannot generalize, definitely. I practice law, I breathe law, and sometimes I feel like pulling everything and throwing it away. But still, I'm optimistic. Thus, I think in such a case, the most you practice, you integrate, you interact with the law, there's more danger that you will basically normalize the values and the practices of your oppressor. Now, and since the law is something that it's a text, and it's a context, and it breathes all the time, and it's dynamic. On the other side, we have to be the same. Now, I will stop speaking in, very abstract way, and I will bring a few examples of what is happening. Although we spoke a bit about the ideology, the form of the Israeli law, and so on, but Recently, there has been other deteriorations with the legal system and the Israeli law. In the past years, we have been witnessing a process of militarization of the Israeli civil law. That I can bring for that 2 examples. One is that the last wave of detentions that took place in the north, where it was much harder for us to defend the detainees who went out to demonstrate against what's happening in East Jerusalem, extrajudicial executions, and so on, where basically the court system perceived the detainees, the demonstrators, as a threat because of the cause they identify with. Not because Suhadi Bishara is dangerous because of what I did, but because of my identity and because of whom I identify with. And this is militarization. Yeah. The other example I can bring for militarization is civic issue in Hiran case that I referred to in the beginning, where basically the court de facto gave the government absolute discretion to displace people within a judicial system that's based on constitutional rights. For me, this is militarization. Going back to even the military regime had some restrictions, even procedural zone. Now it's open-end. So in such a case, pragmatism can be very problematic. And I want to zoom in a little bit, not only in terms of when to deal and how to deal, but also what sort of claims to bring before the Israeli judicial system. And what that can be pragmatic, and that can be ideological, motivated claims, that can be international law, which also has its prices. Yeah. But also, once you decided yes to approach, yes to defend, and sometimes you have cases that are survival type of cases. If your home is threatened to be demolished, it's a survival issue to go to court and to defend yourself, to say, no, you cannot. If you want to be deported, it's a survival issue to go and defend yourself, as compared to initiating legal procedures within the Israeli legal system. I want to touch upon one example related to the kind of arguments we might or might not bring to the court, and I want to relate to some international law framework that's being discussed and even implemented lately in cases related to displacement, also in the Naqab, but I want to relate to the dispositions in Area C. And I've seen from last year, I don't know if there's anyone here from the NRC, they issued a report about the possibilities of implementing the indigenous declaration on the displacements and the Bedouins in Area C, claiming that they're indigenous people, thus the international legal framework applies on them, and the Israeli authorities should refrain from displacing them as indigenous people. Beside the effect of fragmentation that we do to ourselves by claiming that the Bedouins in the Naqab or the Bedouins in Area C are indigenous people, which I don't know what it says about the rest of the Palestinian people, but once you get into this legal framework, it becomes an issue of tuning and even fine-tuning of who is indigenous and who is not. For God's sake, I'm Palestinian, I'm native here. Yeah, I don't care about the framework, whether it identifies me as indigenous or not. Yeah. And I don't want to get into the political aspects of such claims, which basically recognizes the oppressor as such, recognizes the system as such, and let's deal with how we function within the system. But it basically takes my right to struggle as a Palestinian. It takes my right to struggle as nationhood. And it takes my right to struggle against the past grievances. Only to be able, as a lawyer, to consume and probably over-consume the legal tools that are there, and we have to be a bit more careful about it. Thank you.
Thanks. So, in answering your question about the limitations and obstacles, you know, there are many, but I'm going to focus on 4, and I'll do so in under my time as allocated. The first is that, you know, depending on the type of legal representation or the type of case that you're trying to work on, for example, demolitions where there is very little success, or confiscation again where there's very little success, where the whole point is to try to stop the demolition from taking place, and we know that it's never going to lead to a non-demolition, that it's simply a question of buying time, something that I spoke about earlier. One of the main problems is that at a certain point it becomes a house of cards, that all you're doing is buying time and buying time and buying time and buying time, and just like you can build a house out of a deck of cards, at a certain point you put one card too many and the whole thing collapses. And that's exactly what I see happening when it comes to a lot of the work that's happening in Area C regarding demolitions, that there is a point at which people are buying time, but it can become a house of cards. The second limitation and obstacle is one that I alluded to a little bit earlier, which is the idea that international law is being transformed and is being changed, as well as the law of occupation is being transformed and changed. All you have to do is look at some of the decisions that have come out of the Israeli Supreme Court when it comes to the issue of assassinations or the issue of detentions, and you just mirror it onto what's happened in the United States, where they've also legalized assassinations, and they've also legalized detention, they've also legalized Guantanamo Bay and the treatment of people at Guantanamo Bay and so on. And so this is a question of exporting some of the very bad decisions that come out from here, and not only exporting them to other countries, but in itself changing international law. For example, this administration, the Obama administration, is the first U.S. administration not to condemn any Israeli activity whatsoever. I mean, Bush condemned it, Clinton condemned, Bush before him condemned, you name it, Reagan condemned. This is the first U.S. administration not to issue a single condemnation against Israel. So again, you see that there is a changing norm of international law. The third problem, and I think I can still read this, is that you know, this is not a legal battle, and we can't pretend that there's going to be a legal knockout in any way, shape, or form. And the idea that we're relegating ourselves to simply a legal battle is one that is obviously not going to work, and instead we should be legal battles should be accompanying all other types of struggles that are taking place, but they're not. It seems as though, particularly if you look at Jerusalem, that it's simply the legal battles that are standing and not anything else that is happening alongside. There isn't a political battle that is being waged, or a political struggle that is being waged. And this is something that Leah spoke about, but something that I think also I hope she'll highlight a little bit further. And I think the last obstacle is that, and I know you're going to ask this in the next question, but I wanted to go into it quickly, is that oftentimes law is seen as a form of an analgesic. It's seen as a form of aspirin for somebody. I always say this: it's aspirin for a person who with a stage 4 cancer, and so it's a means of saying to the world, oh, well, there's a system that's in place, and the system is going to deal with it. And it's a means of saying to people who are unfortunately on the receiving end of, whether it's the demolition orders or the deportation orders or you name it, a means of saying that the legal system might give you a little bit of reprieve. Now, that's not to say that you shouldn't be engaging in legal struggles. There are times when obviously you need to engage in legal struggles. But I do want to highlight that this can be one of the limitations. How do we overcome it? I think that some of it can't be overcome. The idea that it's going to be a house of cards is not something that we can overcome. This is a house of cards. The idea of changing international law, there needs to be a lot of pushback when it comes to the issue of changing international law. Relegating this to a legal battle, we need to start focusing on battles that are other than legal battles. And the issue of an analgesic also relates to that as well.
Thank you.
Under 5 minutes, see?
Excellent.
The legal representation in these fields raises many problems. First of all, us being lawyers, usually Arab Palestinian lawyers, some leftist Jewish lawyers who represent those cases in different courts, we give legitimation to the system, of course, and the system knows it. And very often the system loves us in a way because we represent some kind of democracy, some kind of freedom, some kind of freedom of speech. They can speak whatever they want, and we very often speak up. At the end, it also gives opportunity to the right wing, to their extreme lawyers, to speak and defend their own Lehava people, for instance, those racists who act directly against Arabs. So we know that this is one of the effects, this legitimation to the system. Another problem is the fact that it causes illusions. People, our clients, the people who are subject to house demolition or any other family reunification problems, they really learn to believe, I think, it's funny, but I tell you, still, they learn to believe during these years in the legal solution. Everyone is running between lawyers. Believe me. 20 women do not stand in a demonstration in the Russian compounds. No, they would run to look for a lawyer, to ask for a plea bargain, to pay the money, to try and release the children, or minimize the punishment. We made it, we lawyers, we made it over legalized system. We give this illusion and people hang to it. And this is a very, very serious problem that politicians should relate to. I tell you nowadays, and if we looked, there were some old friends over there, if we would look some years ago, 20 years ago, 30 years ago, people would be very reluctant. Now, the inflation of lawyers and inflation of legal steps, inflation of courts, inflation of legal associations, give this feeling that perhaps there is this solution. And people are being trapped into it, I'm sorry to say. We have thought many times during this history to boycott. We've discussed it. We've even tried to boycott military courts. We managed to get organized and get the blessing of there was not Palestinian Authority then, but the Palestinian leading figures to boycott the military courts. But very quickly it collapsed because the prisoners, they wanted to know how many years are they going to serve in prison, what is the consequences. They were promised some plea bargains, etc. It collapsed very quickly. And in this, I think we the lawyers, are serving a negative part in this, because we still give them these illusions within the small, it's in small scale, yes, in the court, in this session, in this day, in that military court, we can now mitigate it for you. But, and this illusion, I think, kills also the daily struggle. We thought we had some serious discussions also with Adala and with other associations of human rights, perhaps to boycott the Supreme Court of Justice. Because again, it gives this feeling that perhaps there is a remedy, people pay a lot of money together, we put enormous efforts to make it correct and good and nice, and all the associations address this court, and finally they build bricks of legitimation of the occupation. So there is one important thing about it, yet, not only buying time, but whenever there are these cases, I think, well, at least we are writing history, not we in our hands. The judges, in their decisions and their verdicts, they write the history that will be learned once. How did you legalize the occupation? How did you keep it? How far can you go? How dirty can you be? How inhuman can you be? This is at least the consequence is this written history.
Thank you. Absolutely correct.
Well, I've been getting a bit depressed into this. I don't want to read about it in a history book when what has been destroyed cannot be brought back together, brought back. I think what I'm trying to say is I don't think that it's wise to attempt to appeal to the enforcement by the institutional actors in the State of Israel that apply legislation that was constructed and is interpreted and applied contrary to international law. Okay? Very simple. Yeah. Now, the question is, well, what then? Where do you get enforcement? Well, first of all, an enforcer is somebody whose cooperation is needed or whose abstention from coercion is needed by a violator or a subject of law in order for the subject of law to be comfortable, to prosper, to get what he wants, to avoid what he doesn't want. So there's a form of power that has to be possessed by an enforcer. The only kinds of power that we tend to appeal to are the power that is possessed by the domestic law enforcement agencies of the State of Israel. They will not use their power for our purpose. And it's misplaced to maintain the illusion that they will or can. However, there are many other forms of power. And this is what I was trying to take the thinking a little bit in the direction of how international law gets implemented. Because third parties take their own positions. They internalize international law as they have committed themselves to it. Okay? It doesn't matter what Israel, the Israeli courts, or the Israeli Foreign Ministry thinks. Okay? The third party has to implement their own legislation consistently with their own positions on the status of the occupied territories, the status of democracy and minorities in the State of Israel. Okay. And it's their own internal responsibility to do so, and that responsibility can be tapped if the courts of Israel had the same normative commitments that corresponded to most of the rest of the world, then they would feel the responsibility too. It would be their own internal responsibility, but they don't have it. So you have to start from somewhere. And social enforcement, third-party enforcement, is probably, and has been, I think, events have demonstrated, it is the most promising place to start. And it's the place in which international law demonstrates the greatest utility. You're not going to go to a judiciary. I mean, I'm sorry to say, Israel has conditioned its consent to the compulsory jurisdiction of the International Court of Justice to exclude any matter arising from occupation, hostilities, and hostilities with neighboring states. So you don't have a judicial remedy even internationally. Oh yes, you have a Chapter 7 remedy in the Security Council, but that body will exercise its discretion politically and not be legally compelled. What's more interesting to look at are things like why the European Union, when it became aware of the circumstances of the production of poultry, eggs, dairy products, I'm using this as a simple example, realized it could not permit those products to be imported into the European Union, or goods made from those products inside Israel couldn't even be imported. And basically told the Israelis, look, if you want to be able to sell your products to me that contain dairy, milk, meat, whatever, eggs, you have to guarantee to apply the rule that I apply that does not recognize the domestic authority of Israel's, in this case, veterinary inspection service over the occupied territories and the settlements. This is one small example of processes where the European Union has recognized that its own law was being violated unless it conditioned dealings with Israel on Israel's own application of the rules of international law that the European Union itself observes. I go, and we all go, whether it's to a court or to a third-party government or to a corporation, we go to them and we can only ask them, what do you make of these facts in Israel? What do you make of these facts taking place under Israel's responsibility? What can you permit yourself to do? Can you permit yourself to accept those facts, give them effect? Can you permit yourself to eat food that was prepared contrary to the, let's say, the hygiene rules that you apply in your own home? No. This is a basic opportunity. The limitation that I see in it is our neglect of it, because we continue to hope for the enforcement by vertical authorities, by sovereign states, coercion, by an international sovereign judicial authority that isn't empowered to do it. We're looking in the wrong place to get international law enforced. And I can tell you that the state of Israel has had to modify certain elements of its legislation. It has had to modify its implementing rules in order not to lose the opportunity to deal with others on its own terms. And the most recent example has come from the United States, actually, surprisingly. There's no question of political discretion, there's no question of a will to enforce international law, it's only what the internal legislation of the third party requires of it.
Thank you. There's so many interesting things that came up in all your interventions. Just a last question. Maybe we try to keep it shorter than 5 minutes, your answers, so we actually leave some time for the audience. Do you think that there are some issues that, to begin with, it's worth not pursuing in the legal field? And some issues that are worth more to going to court for or to use other platform that the law allows. So, and this also relates to what Leah said specifically about this kind of law's tendency to cancel other forms of struggle, to make people think that somebody else is already doing the battle and therefore other forms are sort of superfluous here. So let's keep it to 3 minutes each.
3 minutes, okay. Suits me. I want to reframe the question. I think يعني once you practice law as you practice politics and as any other tool of struggle within vision, that's good. Otherwise, it will be playing with the distortion of what you are read to want and so on and so on. And things, again, might vary. As much as we want to strategize for the rights of the Palestinian people on both sides of the Green Line and for the right of return of the Palestinian refugees, we should keep that always in mind. Now, I'm trying to be pragmatic a bit here in my answer. And I think I want to address two possible frame cases that I wouldn't doubt, making things easier for myself, to go to court. These are the survival cases that I spoke about. Either or buying time, hoping that some international political pressure will come from outside, as in the case of Susia, for instance, where it doesn't work like this within the Green Line, but hope maybe to raise some public opinion in the case of the Nakba, for instance. People going out demonstrating in the streets, discussions with the Israeli public opinion and so on and so on. But these are the easy cases that we can decide upon. The other cases that I want to refer to are cases that aim to show, it's not really contradictions, but I cannot find another word. It's contradictions within the system. Hoping that I will be able to use that politically, internationally, and so on. One example is the whole discussion: Israel as a Jewish state, democratic state, and so on. The legal system as based on constitutional rights, and so on, and so on. The type of cases that I can think of here is the relationship between the state and the Zionist organizations. And the major role the Zionist organizations are taking in the official governmental system, in the policy making, in the decision making. Examples I can bring: the GNF, the World Zionist Organization, and the Jewish Agency, as part of the government, de facto, on a day-to-day basis, making major decisions. The fictitious assumption that the legal system is based on constitutional rights, and the fictitious assumption that there is a green line. And there's a differences in the policies between there and here. There's occupation, here is discrimination in best case scenario against minority, native minority, best case scenario. So I would also frame cases that would draw upon these issues that can be used for political discussions, for political awareness, for international discussions. I would also might consider using the law for these purposes. 3 minutes, yeah?
Yes, you did well. Well done. You guys are great. Thanks, Mandy. It's a great question, and I don't think I have a very strong answer for it, because it's hard to speak in a vacuum and to say these are the ones that are worth going to and these are the ones that are not worth going to court. I agree with Sohad's general idea of the survivor cases. I also love the idea of highlighting the contradiction between being a Jewish and democratic state, as well as all of the cases that highlight the system of apartheid that's in place, et cetera, et cetera, et cetera. And all of this, I think, is very useful both to lay documentation for how to conduct an occupation, as Leah was saying, and how awful an occupation is, and how colonialism works in a legal framework. But I think also, should there ever be this idea that we can take cases further, having this documentation in place about exactly how Israel has behaved over the course of the past more than 50 years is, I think, very valuable and very useful. I think that one thing that needs to be highlighted in all of this is that one thing that I feel is sometimes missing is that legal cases are not done in a vacuum. There's obviously other elements that are involved, grassroots activism, the media, getting other people involved, etc. And I think that the best cases are the ones where you can get those three elements involved, where grassroots have a good legal case, and as well as be focusing on media. That's not to say that things are going to change or going to become any better, but I found that ends up being the most successful in terms of being able to carry on a struggle. One thing that, again, just to highlight one more time, is that I think it's very important, and most people, I think, on this panel would agree in saying that law is not the struggle. It's simply a tool. And once we recognize that it's simply a tool, then we can put it in its proper place and start focusing on the other bigger elements in which a legal struggle is an element of the bigger picture and not the only picture in and of itself.
I agree very, very much with the two former speakers. And I want to say that the establishment of Adale really gave this direction a very strong push. And we are blessed by the different cases that the organization is taking and dealing with. What we do need, though, is much more cooperation. Cooperation between different human rights organizations, trying to find some common policy on different issues. Not only we sign advertisement with all the organizations with one slogan. Really think of strategies and policies of how to run the legal venue. We have to do it. And I would think there should be some kind, it doesn't exist though, some kind of supervision of even the activities of different human rights organizations or different organizations that involve lawyers and they work in different fields, because sometimes there is wrongdoing by legal activity in different fields. For instance, I would say military courts that became, from our point of view, from the legal point of view, some kind of a merchant plea bargaining and no common policy of how to react to this military court. Nowadays the people themselves, the defendants, are financing the military court activities because there is a new tendency now to decide upon a fine in each and every case. And to that extent that we ask to open a bank in the military court so that it would be easier to pay all these fines. And but there is nothing above all this activity that dictates the attitude, although there are many organizations that provide lawyers for free for different defense of military courts. We need, I would say, some legal mentor above all this daily activity. Not the big Supreme Court cases. I'm speaking about the daily activity. How to deal with the Ministry of Interior, which is enormous field. How to deal with the land expropriations, etc., etc. I think that Adala is to a great extent such a mentor, but it should take a bigger part.
Thank you for the compliment.
Hmm?
Yeah. Thank you for the enlightening compliment.
Yeah.
I think the politics of all of us here on the platform is pretty clear. And we have really no option but to struggle politically to the extent that we are capable of it. We look to law to give us some advantage because the political struggle means basically informing, educating audiences that wield little bits of power to apply their power and motivate them to apply their power for justice, politically. Now, if you can get your rights and you can get justice politically, you don't need law. That's very clear. Now, the question is, without abandoning a political struggle, how can we use law to expedite it? And that means presenting claims, presenting fact to actors who may be politically very disinclined, as the European Union was, by the way, to impose any of the measures of conditionality it had to impose on Israel. How to get those actors to say, I have no choice, because suddenly the issue for them is not Palestinian rights, justice, Israel. It is, can I implement my own legislation? It's an existential interest. Can I maintain consistency in my policies, between my policies and my activities? It's existential interests that we need also to be able to appeal to, because we need the power of others. We need them to say, I have certain conditions and limits that I have to impose on dealings with Israeli actors, simply to preserve my own internal institutional integrity. This is, by the way a judge would adjudicate in our favor. We use this because we can't get yet the political majority, enough political will mobilized to act politically. So I'm asking us to actually go through a reflection. I think it's wasted effort to appeal to Israeli judicial authorities. At the same time, it's very important to play the game I have in mind, that third parties understand what the legal framework of the State of Israel is, how the Israelis organize their practice and activities, and what they can get close to and what they have to stay away from. And that is the social enforcement process that I think we need to activate if we have any hope of winning politically. Thank you.